for coming. And basically, I want this to be just a short press briefing, but after the results and the verdict having come in this very, very, very important case, for us, it was worthy to bring you together to discuss the verdict as well as what comes next, what's happening next in this case. Now, as you know, all of the defendants were found guilty on the 44 counts of the information. We did, it was just every single one. And so it was we were able to prevail in this. As you know, just a little bit about the history, this case started with an audit in 2006. That was the audit of the Inspector General, the local Inspector General, Stephen Van Beverhout, in a joint audit with the Department of Interior. And in that 2006 audit, what they found, what the Inspector General found, was that there was quite a bit of waste, fraud, and abuse in the Roy Lester Schneider Hospital among the executive staff. At that point in time, a criminal investigation, after the audit report was released by the Inspector General, a criminal investigation did ensue, a criminal investigation by the criminal investigator of the Inspector General's office. Because as you probably know, the Inspector General's office does have the ability to do criminal investigations and submit them for prosecution. Now, the Attorney General's office became involved in this case early on because when the investigation, or during the course of the audit actually, there was difficulty in getting information from the hospital, from those executives, particularly Mr. Carty and Mr. Najawicz, but primarily Mr. Carty. But there was difficulty in getting that information, and to the point where we had to, for the first time, actually take them to court, where we had an action to get them to obey the Attorney General's subpoena. Now, initially, letters were sent out, as normally in audits, by the Inspector General, and Mr. Van Beverhout even having issued letters requesting contracts and other information. That was rejected, and they came to the Attorney General's office and to request assistance. Then once we issued the subpoenas, still we were not getting the information. So we went to court on that, and then subsequent to that, then they were ordered to release information based on the subpoenas. Now that the investigation, the criminal investigation ensued, from the very beginning, the Attorney General's office at that point in time was very much involved with the Inspector General's office in the investigation. Particularly, have here with us as a part of the prosecution team, investigation team, Nicholas Peru, and he was the investigator and is the investigator for this matter from the very beginning, working with the Inspector Generals. So you worked very closely at the time. I was a prosecutor back then when the investigation ensued, and then continued on for prosecution of the case. First trial ended in a hung jury, and at that point in time, on that very day, we immediately got the authority from the then Attorney General, Vincent Frazier, for us to proceed with a retrial, because then we had that choice to do so. Since then, there have been many appeals, many motions, just a lot of things that created delays with respect to the case, and so now we come here, and we're here now with this particular trial, which is a new trial. And as trials are, even though it's based on the same facts and the same investigation, it becomes a new trial because we have a whole new team. When I came on board in April of this year, I first learned that the hospital trial, which I prosecuted so many years ago, and I came back also actually to the Department of Justice, and I found out that it was actually scheduled for trial in October. And it was important for me at that point in time to pull together a strong prosecution team for what was here at the Department of Justice. And I got Quincy McRae, who is the criminal, where is he? Quincy McRae, who is actually the chief of the criminal division for St. Thomas. At the time, he was actually handling a double murder trial in St. Croix. And during the time when I was deciding, I had to pull together the team, and I had to give him that news, like, look, I'm going to need you, and I'm going to need you to lead the team. And he's like, okay, I have this trial. Yes, I know that. But he knew that right after that, which was also a very challenging trial as well, that after that, then he'd be getting on board with the hospital case. Then also Sigrid-Sprotte. Sigrid-Sprotte just came back. She's actually a part of the Justice family, but she left a while and then she came back to the office. But she was new. She came on board in May of the year and immediately started working on the case and researching and looking at, just looking at the past, all the documents, and getting familiar with it. And John Tolud, Attorney John Tolud, also a part of the team. John Tolud, he's actually the Assistant Attorney General assigned to family, and he holds down the court in the family division. And very important, very much depend on him immensely. And I pulled him on to the team because at some point a few years ago, he was assigned to the case when he was a part of the white collar section, and he was a prosecutor in the white collar section, and he was assigned, so he was familiar with the case. So it was like he would be the best person to pull, and then pull together this team with Quincy McRae's lead. So and it's an excellent team. These attorneys are excellent, very talented. I just thank them, and it's just worth it. And it's so great to see a team of professionals just really diving into the case and really, working the case. This is the backstory of these cases. It takes so much time and effort. I mean, they've been working 24/7, including in Peru, not just the attorneys, but in Peru, in working this case, interviewing witnesses, preparing these cases for the past 6 weeks at least. And even before then, the preparation and everything takes time. I also want to recognize the staff of the Department of Justice, particularly in the criminal division, because when I took the attorneys off of their cases, their caseload and everything, to then focus on this one as a team, the attorneys in the office, of course, had to take on a lot of the responsibilities and the cases and everything, and I know that it was somewhat of a burden because we definitely a little short-staffed anyway, and so it was quite a burden, but it was just something that we absolutely had to do. But they did, and I really appreciate it, and it's just a part of the teamwork that we really try to foster. Something, that's interesting to me, this case also created a lot of firsts, and first of all, when we first started, during the time, there are not many cases where we actually prosecuted under the criminally influenced and corrupt organizations. That's our local racketeering statute. And one thing that is particularly forceful about that statute is that it actually gives the ability of the government, gives the government the right to ask the court to restrain properties. Whether personal property or real property, restrain properties until after there is a conviction. And if there's a conviction, then we can forfeit those properties. So the forfeiture provisions are very, very important. And that was about the first time that we really stretched it, particularly where we sought restraint of properties that weren't even in the Virgin Islands. And so it was a case of first impression going to the Virgin Islands Supreme Court, where it was appealed, the orders of the Superior Court allowing us to restrain properties from bank accounts and real property in the States as well as in the Virgin Islands. The defendants did appeal that and went to the Supreme Court, and the Supreme Court ruled that we did have the authority, and it was legal for us to be able to reach that far and to be able to restrain properties and ultimately forfeit the properties or seek forfeiture of the properties once there is a conviction. So one of the other first is also when we had to take them to court in order to enforce the AG subpoenas. Now, Attorney General subpoenas are used and pursuant to statute in order to obtain records and everything for criminal investigations. And in this particular case, we were faced with, for the first time, that we had people just saying, no, we're not going to do it, not obeying the subpoena. So I recall that during that time we said, okay, exactly how are we going to enforce it? Because at that point we had to. So that's when we went to court, and we went through the process of having to do that, and did get a favorable ruling. This is the first also, was brought to my attention, of a SECO case that actually went straight to trial, throughout trial, with forfeiture provisions and everything. So it will go through the whole spectrum of the crime, to the prosecution, to the restraint of properties, conviction, and then the forfeiture of properties. Hopefully we do have the hearing scheduled for next week, I believe. Is it next week, Thursday? Next week, Thursday, for the forfeiture hearing, where we would be able to appear before the court and determine, try to get the properties forfeited. With respect to that, it's been quite a long time since the properties have been restrained. So what the team is going to be doing now is really working very hard in looking and seeing what the status of the properties are, where they are still there, what is going on, and everything, so that we can be properly prepared for next week, Thursday. Okay. And also sentencing is scheduled for the December 13th, 2019. And so that would be the next. So the next step would be the forfeiture hearing, and then after that, then it would be sentencing. Okay. Does anybody have any questions or anything for me or the team?
Yeah. Thank you, ma'am. Robert Moore with the USVI Consortium. Mm-hmm. Is there an estimated value on the property subject to forfeiture? And can you describe what that property is?
Well, there's actually a list of properties. It's including bank accounts. And it was attached, it is a part of the public record and attached to the information. I can't give you the entire list now, but it is public record and you can have that. It includes several houses, real estate in the States, bank accounts in the States, and some properties here, as well as some properties were actually during the course of this held at the court, for pending forfeiture proceedings, as well as in certain attorneys' bank accounts and everything. So there's a lot that has gone on with that. And also, as far as the valuation, since so much time has passed, we don't know, and that's a part of the reason why we're going to have to really look into it and see where it is, what the status of the properties are. It included vehicles. I don't know if the vehicles are even worth, we don't know what they're worth. It's been, over 10 years, let's say, for example.
What about the the PowerPoint presentation that was included in the closing arguments by the prosecution? Was that a first?
I'm going to ask the criminal chief, but I don't think so. I believe, was it the first time? We used PowerPoint. That's right, because we used PowerPoint in 2008. Mm-hmm. But we were only able to use it for the opening arguments, and then there were problems with everyone being able to see and to visualize it because we were in a small courtroom, so then we couldn't use it through the trial. But as far as using PowerPoint throughout the trial, mm-hmm. and in closing, I don't know, have you done that before? Have you been doing that?
Just once. It may have been with Attorney Veranda. Mm-hmm. We did it before. It was Jaguar's murder case. Mm-hmm. That may have been around 2013.
Mm-hmm. Well, and I'll say I'm one of those people, I like, bringing everything to the 21st century. I wasn't sure exactly how many people were using that, but I really think that and expecting that our prosecutors will be really getting much more involved in technology and using technology in the courtroom. So I'm looking forward to doing that and seeing that happens as well.
So in your opinion, do these convictions or the outcome to this case send a message at all to the legislature about the importance of funding a white-collar crime unit?
Well, I don't know. I never thought of it that way, that it would send any kind of message at all. And I don't know that they don't know the importance of it, So, but I would say it is definitely a white-collar corruption case that is more complex than normal, and involves a substantial amount of money. I don't think we've had any case that is quite that involved and with that much money involved either. So it is a unique case, and I just not making necessarily a connection between that, but that and today, what's happening today, but it's definitely important, and these cases are all important. But one thing it does show though is that, well, yes, you have the tools and everything, and you're able to investigate and prosecute, and justice can be done. But I think that it sends a message. The prosecution of white collar crimes, whether or not there's a unit to do that, is important, because these types of things should never go unchecked in government. It actually preserves and upholds the integrity of government, and so it should always be in the position that we are ready and able.
Somehow in the conversation surrounding this trial, I heard some people who said that not only Schneider Hospital, but other agencies have sort of a protocol of secrecy around their contracts. And I'm wondering if justice would think to address that, kind of practice in government agencies.
Well, I'm not sure what practice that would be. But contracts, generally speaking, should be available to the public upon request, unless there's certain exceptions with respect to certain type of information, maybe within the contract. That's pretty much laid out in our statutes, is what those exceptions would be. But generally speaking, they should be available and made available upon request. We are not the Attorney General's office, although we are charged as the Attorney General. I'm charged with giving advice and counsel to agencies in the government, all of the agencies and boards and commissions. I'm not necessarily the police of the boards and commissions. So unless there is something that comes to my attention where there's a request or maybe a question, which sometimes happens, there's a question that comes from the press and they would ask, is it okay to hand this over? And that sort of thing that I can help them. But it's not something, as you're asking, that I necessarily would go and start to investigate that issue. But yes, they should be contracts should be under the Public Records Act. In fact, it is, unless there's some unique exception to that.
Okay, thank you.
I know the valuation is possibly forfeitable property is still a dispute, but how much was the total dollar value at issue here in terms of embezzled funds, and how much of that are you hoping could be recouped, or do you think the hospital will get a lot of that money back?
I don't know. I think what was it, about between 4 and 5 million total?
I've heard a few different numbers. I wasn't sure.
I would definitely say, as far as just from the Scotia bank account, it would be pretty close to over $3 million.
Okay.
So I would say between maybe $3 to $4 million at the very least.
Okay. And in terms of forfeitable assets, are you hoping to get back a percentage of that, or is there?
We're hoping, as with forfeiture, we're hoping that we'll be able to recoup something. We can't tell how much, and that's the whole idea also. As far as restitution, that's something that's ordered by the court, and actually the defendants actually are responsible for restitution, and that is making them whole, making the victim whole. In this case, will be the hospital or the government of the Virgin Islands.
Obviously, it's a different prosecution team, different jury, but same facts, same case. I know it seemed. I obviously didn't cover the first prosecution, but I read some of our archives, and it looked like there was a lot of similar witnesses and similar evidence presented. Mm-hmm. Why do you think this was such a different outcome?
I don't know. A different jury, a different time, and a super team. Hey, what can I say? But all we can do is that you present the evidence, present the evidence, and argue the case. They did an awesome job. I am so proud of this team, and I'm proud of my all of my prosecutors. We have great talented prosecutors here, and this is just some of them, really. And so I would say that different time, different place, and different jury, especially.
If any of them would like to take the opportunity, I might like to hear some of the challenges that were faced in presenting such a complex case and trying to get jurors to understand. I mean, I know everyone involved had a hard time following some of the concepts and financial, lingo. It was a really complex case. So, how did you present that to a jury in a way that was digestible?
Anybody want to answer that? You want to, Sigrid?
We just, for me, I relied on my witnesses to teach me about what they knew.
Yeah.
And just meeting with them and relying on their guidance and what their background was a big strength for me, because I came here in May. And 6 months later, I was in the trial. I didn't have years to prepare for this, and so they educated me, and that was the most important thing for me to get through this. So it was really the witnesses that helped us with this trial.
And I think that the point, I don't know if someone else wanted to say something.
Just for this case, I would say as far as the jurors, I would say every day that we went to court, I would say that they would be attentive from the start of court from 9 o'clock until 5. They would be sitting there taking notes every day, listening to all the witnesses. So I think they were very interested in the case, and they were trying to make sure that they made the correct decision, and that was from the start of the case until the end. It lasted approximately 6 weeks, and for all of those 6 weeks, they were taking notes throughout the duration of that trial.
And the last trial also took 6 weeks, which is interesting. We thought it would have been shorter this time. But one thing that I want to say also, coming off of what Attorney Sprotty had said, is that that's the thing. She's relying on her witnesses and the evidence. And that's something that's very important, that when we have the investigations and prosecutions, we are led by the evidence. We don't target people. We target the evidence. We follow the evidence. We don't follow people. And when you follow the evidence, that's what takes you and leads you in the right direction.
And correct me if I'm wrong, I don't want to keep it all night. A lot of the evidence was pretty circumstantial. I mean, I didn't hear any major smoking gun, or in terms of something you could point to. And the defense made a lot of that, of saying, there's no direct evidence that anyone was plotting, or I don't know if you could speak more to that.
Yeah. Well, one thing I would say, and as the jury is instructed, and sometimes people have a misconception that somehow circumstantial evidence is somehow less important than direct evidence, but that's not the case. And the judges always instruct juries as to that. It is just as strong, just as reliable. I wouldn't necessarily agree with you that there wasn't direct evidence, because there was, and I don't think you were able to actually attend the whole trial this time, but yes, there was a lot of direct evidence with respect to the documents, the letters of direction to pay large sums of money, for example, signed by the parties, signed by the defendants, and then paid out. So that's direct evidence. That's considered direct evidence. But still, there's also circumstantial when you're dealing with conspiracies, when you're dealing with these complex situations, these complex fraud cases. You do deal with circumstantial evidence as well as direct.
That's a challenge.
That's what makes it more challenging and more complex.
Well, congratulations.
Thank you.
Anything else? No? Okay.
What about Attorney Carty? What's to become of his status with the VA involvement?
I don't know. That's a completely different venue. That would be something for the bar or the Supreme Court to have to consider. We wouldn't have anything to do with that on this side. Okay. Thank you so much.
Thank you.